name is Norman James, and I have the pleasure of interviewing Howard Orenstein. This is the 1st of April, 2014. This interview is part of the Connecticut Bar Foundation's James W. Cooper Fellows History of Legal Services in Connecticut project. And so, Howard, thanks very much for giving us some time. And we need to say that we're doing this through the magic of Skype. Howard is in his home in California, and we're here at Quinnipiac University in Hamden. So, Howard, welcome again.
Thank you.
We're asking folks, Howard, to begin by give us a little brief bio of your legal aid history so that we know the context of some of the conversation we'll have.
Sure. I got out of law school in 1962, and I spent 2 years with a Fairfield County law firm in Bridgeport and Westport. And at that time, I was representing quite a number of people who were very well-to-do, some of them quite famous, and handling the kind of law that a lot of young lawyers think that they want to handle when they first get out of law school. And then I found out that there was an opening at the Legal Aid Society in Hartford, working for Bill Graham, who was one of the early pioneers in legal services in this country. So I went and interviewed with Bill. And so from 1962 to 64, I was with the Shine Law Firm. 64 to 66, I was with Legal Aid in Hartford, which is the Legal Aid Society of Hartford County, as their assistant director. 66 to 67, when the Office of Economic Opportunity began to fund neighborhood law offices, I became the senior attorney and director of field operations for neighborhood legal services in Hartford. Then I had a period from 67 to 75 when I served as chief counsel to the Commission on Human Rights and Opportunities and also conducted a private practice. During that time, I served on the board of directors of Neighborhood Legal Services, including serving as its chairman, and I was a consultant to the Office of Economic Opportunity Legal Services Division, and also interacted very regularly with legal services lawyers because the work that I did at the commission and the work that legal services lawyers do have a lot of crossovers, particularly in legislation. Then I came back to legal services, 1975 to 79, as executive director of Neighborhood Legal Services in Hartford. And after 79, I came out here to San Diego, where I helped start a new law school.
That's quite a resume. Can we let's go back to the earliest time when you first started with the Legal Aid Society. This is before the federal funding.
Right.
And was there just the two of you working there, or was there bigger staff than that?
There were the two of us. Okay. We were two lawyers in the basement of City Hall in a county of 690,000 people, and we were all that existed for poor people in Hartford at that time.
And so what kind of legal work were you doing for them?
In those days, it was landlord-tenant, family, criminal law. We did civil defense, particularly in the consumer area. And then Bill and I both would, from time to time, take on particular cases that had a particular interest that took us out of the ordinary caseload. And there were a couple of those which we can talk about later on.
So I don't want to jump too far ahead, but what was the difference? Was there any difference in the caseload from the Legal Aid Society prior to the federal funding, and what happened once Neighborhood Legal Services got started? Was it pretty much the same kind of clients and legal work for the clients?
Totally different. The Legal Aid was a community chest-funded organization of long history, and as I said, we were in City Hall when the federal government began to fund neighborhood law offices. That put us out into the neighborhoods, produced a completely different clientele, and a lot of issues that had, I think, never been really covered before, because we were no longer doing just the the day-to-day one-on-one, but we had some funding. We could increase our staff. We could concentrate on certain special areas. So it was a very different operation altogether.
Can you give me an example of some of the kinds of work that you were able to do with neighborhood legal services and the federal funding that you hadn't done with the community chest funding?
Well, first of all, at Legal Aid with Bill Graham, he was a remarkable man, and I did get to do some very interesting work with him. And when Neighborhood Legal Services came along, I would say we got to do more, and probably more, maybe more ambitious, because we had more staffing and also a wonderful network of relationships with the private bar. Where, for an example, one case which we can talk about later, our office handled the first legal services victory in the United States Supreme Court, which was a case called Shapiro versus Thompson. We only had 4 lawyers at that time, but we had 28 lawyers working on the case, including the president of the bar, a fellow by the name of Bill Moeller, who was a wonderful man,
Sure.
and including John Newman, who was the president of our board, who got us a Harvard law professor to come in and argue the second round on that particular case. So it was just a different dimension, is what I would say.
And was there any political constraint on the Legal Aid Society being in City Hall? I mean, did you or Bill Graham feel that maybe you couldn't be too aggressive because of the connection with the city or government, or was that not a factor?
I don't think it was that. I think it was the perception of the office by the clients. The clients that came to the Legal Aid Society tended to be not from the very most impoverished parts of the city. They were the people who were comfortable coming to City Hall. Whereas when you're out in the neighborhoods, and our first office was in a warehouse in a part of the community where there had been 3 murders in the previous month. It was a different climate, and the trust that we had to establish with that client community, that was probably one of the major concerns for the program when we first started out, because people in that community thought of lawyers as the ones who came after them, not the ones who assisted them.
Yeah. So, and there were, how many offices did Neighborhood Legal Services have? 2 or 3 at the beginning?
We had, we opened up one in the north end of Hartford, which in those days was primarily a black community. We opened up one in the south end of Hartford, which at that time had a lot of Puerto Rican people and Latin American people. And then later there was a third office which was more of an administrative office. Basically, the city was divided along where we thought the client services would be the most effective, and in all cases, it was not in the kind of offices that we had, let's say, in a private law office.
Well, let's talk a little bit about the kind of cases that you did at Neighborhood Legal Services when you started there. Actually, let me ask one question first, and maybe that'll slide us into the Shapiro case, because you suggested that the private bar was very involved, and I'm gathering then that you got a lot of support from the local bar in establishing Neighborhood Legal Services and getting it going.
That's right.
Yeah.
The structure of the board helped. We were a board that had I think it was 1/4 community people from the neighborhoods, 1/4 legal aid people, 1/4 bar people, and let me see, and the other one was the community action program people, which tended to be also neighborhood people. But the presence on the board of some of the really more distinguished members of the bar didn't hurt.
Yeah.
And Bill Graham had already established enough of a reputation with the legal aid program, so that it was really a different climate. I know, for instance, I worked in Bridgeport, and I remember some of the climate there. I did a little bit of exploring out in Towel and Windham when I was in Hartford, and I know that there was resistance at
Sure.
the bar bench. Both Hartford was different.
Right. And was the bench no problems from the judges either?
It depended on who the judge was.
I'm wondering about the landlord-tenant in particular, because I know in some other places, judges were pretty reluctant to follow the law as we interpreted it.
I don't remember that. If
Okay.
it was so, maybe I've sublimated it, but I don't remember that.
Okay. Well, and it's really interesting because you're not the first person to talk about the experience in Hartford, which is really very different than in New Haven, in Towle and Windham, and the Fairfield County. So that's an interesting. Maybe the local climate really does make a difference.
Well, if you have, I mentioned John Newman.
Yeah.
Jeff was at the time was U.S. Attorney. He later was on the Second Circuit. He suggested to us when we had won the first round in Shapiro in the U.S. Supreme Court that the second round, which had to do with federal legislation, it might be good to call in Archibald Cox. I don't think most programs would have had that ability to be able to do that. It was basically he came in and argued the case for us the second time around.
Why don't you tell us about the Shapiro case? What was involved and how that came about?
A lady who was expecting a child who was on welfare in Springfield, Massachusetts. Her mother lived in Hartford. She wanted to come to be with her mother so her mother could help her during her pregnancy. When she got to Hartford and she applied for state welfare in Connecticut, they said, well, you haven't lived here for at least a year. She actually thought about going back up to Springfield, and they said, well, you've moved away from here, so you're also not qualified. And here she was pregnant and not all that physically feeling well. So the case had to do with the issue of what is sometimes called the right to travel, but is more particularly was really the right to migrate between states and not to be penalized for moving between states. It was a very one of the things that interested me was when Judge Bork was up for confirmation at the U.S. Supreme Court. He said he didn't like Roe versus Wade, and he didn't like Brown versus Board of Education, but he liked Shapiro versus Thompson. And the reason he liked it was that it related to something very basic and fundamental in the American way of life, namely to be free to travel.
So what was the decision to file the case? Was that, and who was doing the work and those kinds of things?
It started, there was a little history before. Bill Graham had a case in New Haven, maybe, I don't know how many years before, but he had told me about it. That was under a prior statute in which if you came into the state without visible means of support, the state police put you on a bus and sent you back. All right. He brought a suit, they backed off on that, and they passed this law, which was obviously an indirect way of doing the same thing, right? So Bill was obviously helped on the case. I supervised primarily those 28 lawyers in terms of correlating all the portions of the brief that we put together. The lead counsel was Brian Hollander, who's a very bright and capable young man, and everybody else in the office, which wasn't that many people. Sid Shulman, who's now the mayor of Bloomfield, Stu Rosen, who went to the Internal Revenue Service, and Stu Schimmelman, who's a judge in Connecticut. It was a very collaborative experience.
And how much experience did all of you have when you started that case?
Well, let's see. We started it in probably 67, 68. I got out in 62. I was the oldest one, 5 years.
Okay, all right.
And Brian had clerked for the courts. Everybody else, I think, Sid had just come out of the Air Force. I don't remember what's the two stews were doing, but we were all very young.
Right, right.
And of course, you know, a very, very educational experience for everybody involved.
And so the case went from the federal district court to the Second Circuit and then the Supreme Court?
We didn't have to go to the Second Circuit. We used a procedure in those days was available. If you were asking a federal court to declare a state statute unconstitutional, you could get a three-judge court. The three-judge court decision was appealable, not by cert, but appeal directly to the U.S. Supreme Court. So that was a learning experience also, because Bill and I had, I don't remember how much before, we had tried to get another case in the U.S. Supreme Court on cert and had failed by one vote. The procedure itself was very important.
Was there a trial of any substance at the district court level, at the three-judge court level?
Yes, there was.
Factual. I mean, we had to introduce factual evidence.
Yes, of course, the plaintiff and actually the defendant Shapiro, who was the state welfare commissioner, testified, and he was quite helpful to us. I don't think that he believed that the statute was a good statute either.
Okay, all right, all right. But most of the work was the legal argument that was made both before the three-judge court and the Supreme Court.
Well, I think the thing to know is that, for instance, I teach constitutional law and have thought it out here for a long time. That case is in all the common law books. The reason it's in all the common law books is because it was the what was called then the high water mark of equal protection. The argument that the right to travel was a constitutionally protected right was found in only one previous case, not directly in point, and a law review article. And so we had to really put together a brief that showed all the various ways in which it did affect people constitutionally. And when the Supreme Court ruled, I think it was 5 separate grounds upon which they found it. In fact, they more or less said, we don't care to tell you exactly what ground it is, but it certainly violates the Citizenship Clause. It probably violates the Privileges and Immunities Clause of both the 14th and Article 4, Section 2, and equal protection, probably the Commerce Clause. And Bork's opinion, which happens to be mine, is that it was it had to do with the structure of the Constitution itself and the relationship between the states and the federal government, so that the states could not establish barriers to an American citizen traveling from one state to the other. I agree with him on that, and that's I don't know if any of the judges ever said that.
Oh, interesting. Now you mentioned a second round of the Supreme Court. What happened there?
There had been a congressional act which the state argued had authorized the one-year residency requirement by the state. We took the position that it made no difference, because if it was a violation of the Constitution, Congress couldn't do it either. Right. But it helped to have Archibald Cox make that argument for us rather than 4 young guys from Hartford.
Yeah, right. And he argued the case in the Supreme Court, right, for you?
The second round. The first round was argued by Bryant, and the second round was argued by Archibald Cox.
And when you say a second round, they didn't decide one case and then another one came up. You had 2 separate arguments on the same case.
They asked us to brief the question separately after the first argument had been made.
I got you. Okay. And who was it that organized all of these 28 lawyers from the local bar? Was that John Newman's initiative, or Bill Moeller's, or how did that come about?
I have to say, with a sheepish modesty, I did.
Well, good for you. Good for you.
I had. There were an awful lot of lawyers in Hartford that I had great respect for, and they all pitched in. They just, I'd say one fellow who was, I don't want to mention his name, but he was a sole practitioner, and he concentrated on problems of the disabled. He was disabled himself. I gave him a portion of the equal protection brief. He did an unbelievable job on that. And these things all got, and Bill Moeller did a part of the brief. And I don't know if you know, but when they did the Connecticut General Statutes annotated, he wrote a lot of the annotations.
Yeah.
To this. So we had wonderful talent going in, and coordinating that and organizing all that. I had fun doing that.
Well, yeah, that sounds like it's hard to have such a high point and so early in your career. I'm sure.
Yes,
it really is a neat story. Other kinds of cases that were there other cases that you were able to do that made some change in the law or clarified some of the law that helped lots of clients?
I just happen to have a list. I'm looking at them here. I think the thing that we tried to do was have what we called test cases or impact cases come out of the caseload.
Right.
And so each lawyer in the office tended to take one kind of matter. Stu Schulman was doing consumer, so he took on the question of holder in due course in consumer transactions. He won it in court, and we also later got it put into the statute law. That was a big deal, really, at the time. Sid Schulman did a lot of community education and community organization, profound effect upon the community, I would say. Let's see, I may be forgetting some, but I'll give you a couple that I enjoyed. One of them is, I'll give you a citation because we're lawyers.
Sure.
Arbro versus Hegstrom, 261 Fed Sup 397, 1966, and the Joseph versus Connecticut, 385 U.S. 982, 1966. Those are two cases that Bill and I worked on. They had to do with when counsel would be appointed in a criminal case. They were after Gideon and before Argersinger. We almost got it done in the U.S. Supreme Court before Argersinger. That's the case we didn't get that last fourth vote. But we won in the district court on a habeas. And that produced appointments from that point on in Connecticut for criminal cases if you had a possibility of loss of liberty. That was an important case.
Yeah. And that was one that must have started when you were with Legal Aid Society, right?
That's right.
Yeah.
That's right. That's what I meant when I said Bill taught me habeas corpus. He taught me a lot about federal procedure and appellate law. I mean, I can't say enough about him. He later also became a Superior Court judge.
Yes.
Let's see. I would say Berlinski versus Ovalette, which is 164 Connecticut 482, 1973, was not our case, but they used my brief. And what it was in those days, insurance companies would bring suits on behalf of their insured against defendants in, for instance, an automobile accident case. Okay, and I really handled that matter because of a personal gripe. I had too many of those files on my desk, and I wanted to figure out a way to get them off my desk. And one of the ways that I figured was, and this is pretty interesting. At common law, Connecticut recognized champerty, barratry, and maintenance. That was something I learned in law school and never heard again until we had this case. What I argued in briefs before the Superior Court was that when an insurance company paid its insured and then was subrogated to that insured's rights in a personal injury action as opposed to a property action, it violated champerty, barratry, and maintenance. And I found a case it was either Kirby, Root, or Day, which you will know is before Volume 1 of the Connecticut Reports.
Right.
And what happened was, every time I filed discovery to flesh out whether or not this was a subrogation case, the insurance companies backed away. And so I got all those files off my desk.
Uh-huh.
Then after I left Legal Aid, Bill Graham called me and said somebody in New Haven wanted to challenge it, and could they use my brief? And that was Berlinski versus Ovalette. That was a fun case.
There you go. Interesting. Can we jump from the time you were there in the late 60s when Neighborhood Legal Services started? You said you came back in the later 70s.
Right.
Right. What was different about the kind of work, the clients, the atmosphere between those two times?
Well, in my first time around 66 is when legal services started. I mean, I think New Haven was first, we were second, if I remember rightly. So that was, I think you've been doing these interviews and you talk about pioneering. That was pioneering, kind of.
Yeah.
By the time we got to 75 and 79, the reason I went back was, honestly, I was at the Commission on Human Rights. I got a call from the board at Neighborhood Legal Services. They said they were losing half their funding. And could I come and help? And so I went back primarily, initially, to raise funds. And I did. I raised, I took, and actually, I think I tripled or quadrupled the budget. So that was what I was there for. And as a result, of course, I recruited a lot of staff and set up a much more firm organization there. And it was different at that time because I think legal services was established. The lawyers were much more, I think, much more adept and much more experienced. I primarily administered, although I did do casework also. I had one in particular, Kathy Bresnahan case, which was a young lady who tried to kill herself. And it was almost 2 years that case lasted when we were doing battle with the Department of Children and Youth Services because she was a ward of the state. I did that with Sister Sue Ann Shea, who you may remember.
I do remember. Mm-hmm.
And who was also a wonderful person. So I did a selective casework, and I did primarily fundraising, outside representation. I mean, the fundraising came from, I think, 3 or 4 different sources. So there's a lot of work involved in getting that money.
And the loss of funding, did that have to do with the Legal Services Corporation and its efforts to create a statewide program at that time?
No. It had to do with the Legal Services It had to do with the Legal Services Corporation, but not the statewide program.
Oh, okay.
It was simply they were cutting some of the funds, and the program was small enough then, so that cut was really a very, very serious cut for the program.
Right. Do you remember? I mean, Neighborhood Legal Services in Hartford did not become part of what we know as Connecticut Legal Services. And that occurred in 1977, so you must have been involved in, and how was Hartford able to stay out of that merger? Do you remember?
It was well, Hartford and New Haven, it depends on who you talk to.
Well, I'm talking to you, so I'm curious about your perspective.
In terms of what the desires or wishes were of the Legal Services Corporation. We were told that we were not necessarily going to be included in that program because the Hartford and New Haven program as standalone programs weren't included in those plans. There was some indication to both me and also Bruce, who was running the New Haven program, that maybe that wasn't quite so. And so there was quite a lot of long struggle to maintain the independence of the program.
Right. Interesting times.
Yes.
Yeah. Well, and actually, one of the questions we've been asking is about funding, and since you were involved in fundraising, where the funds came from and how they had to be acquired, how much, if any, impact did that have on the nature of the legal work, or I don't want to say how aggressive the work, but what was the impact on what the folks on the front lines were doing from funding and lack of it, and where it came from?
It's that's a good question. I don't know if you're a little younger than I am, so I don't know whether you were around when the Green Amendment came in.
Yes.
Remember that?
Yeah.
Well, we were doing criminal work in those days.
Right.
And when the Green Amendment came in, we couldn't do criminal work. But you could do criminal work if you got funding somewhere else, as long as you didn't use legal services money.
Right.
That was one thing. We got community development block grant funds. That was from the city. And that primarily was, I think, consumer, family, housing, and senior citizen. I think that's what that was. I'm not sure I remember that right. We got some money from the community chest. That was a broader kind of money. We got Title 20 money, which we used for a nursing house, a nursing home ombudsman, and for training, training of lawyers. So each piece of the money did have scope of services attached to them, and so it did affect us in that way. I wouldn't say it affected us at all in terms of the nobody put any brakes on what the lawyers were doing, put it that way. And in fact, we're going back to the bar question of how the bar received us. The bar was very, very, very determined that legal services lawyers in Hartford would be independent, would make independent judgments and not be controlled, for example, by the community action program or by the neighborhood people, right? And so that turned out to be a plus in that sense, because nobody was attacking our ability to do whatever anybody else would do as a lawyer for a client.
That's really an interesting story, because it really is so different than the experience in some other parts, even of Connecticut, and of course different in other parts of the country as well.
Yes.
So, you've mentioned the names of a number of people who you work with. Who among them were the most memorable? Or maybe who among them would you consider to be mentors?
Well, certainly before I got to legal aid, Leonard Shine, who was my boss at the first firm I worked at, I honestly believe that what I learned at his firm helped me a great deal in my legal services and legal aid work, because there was a climate, as I think you know. It's sort of like the clinical versus the classroom teacher in law school. Some people draw a distinction between the two. I never have. I've always thought they were the same.
Sure.
Legal aid lawyers and, quote, regular lawyers, there was that kind of a feeling. I never had that problem, because I had been a, quote, regular lawyer with a firm that most people knew about, was a good firm. And also, I always felt very comfortable with the members of the bar who were on the board, and the members of the bar that worked as volunteers in the program, things like that. So Leonard was a help. Bill Graham was a real mentor. Bill was an African American lawyer. I think there were only two in the state. Bo Sparlow, who became a state senator and a judge, and Bill, and then later Scott Melville came along with Gene Spear, but and I think Bob Glass downstate. There weren't that many black lawyers in the state, and Bill not only taught me law, he taught me about a lot of other things, because we were working very heavily in the black community. And it was important for me to be sensitized to what I was doing, and I didn't have the background or the understanding to do that without his help. His help was wonderful in that regard. Let's see, other mentors. John Newman certainly was a big help, but I would say Bill Moeller. Bill Moeller was a giant in the law in Connecticut, and he took a liking to me. He had been the fellow who taught us the bar. He and Judd Bill had a bar prep course, and I took his course. And all along the way, all through my life, he seemed to pop into the picture. There was a time when Bridgeport was under attack by a very well-known politician in Connecticut, and I think Jim Trowbridge was running the program then. I'm not sure if I'm right about that. I was appointed by the state bar with William K. Cole of Robinson and Cole, and Bill Moeller, the three of us, to investigate that. Well, Bill made me the chair, and he had me write the report. I mean, that was something.
Yes.
You know?
Right.
And of course, we found, as we should have found, that Bridgeport hadn't really done anything wrong. All right. He was a great mentor.
Yeah.
A great mentor.
So, you obviously have had a very long career since your time in legal aid, legal services. How has that career been influenced or been impacted by your work with legal aid and legal services?
Profound effect. You were at the work longer than I am, and it gets into your guts. I grew up in a neighborhood where I saw a lot of things that I didn't think were just, and I decided to become a lawyer when I was 10. And I wanted to be a legal aid lawyer a lot when Bill Graham said to me, after I had spent 2 years representing wealthy people, he said, any client that comes into the legal aid office when you work here, you understand they've just put down a $100,000 retainer, and you treat them accordingly. All right, that stayed with me, and it taught me a lot about Bill Graham. Well, ever since I left legal services, in terms of formal, I mean, I went into legal education, and I taught constitutional law, civil procedure, trial advocacy, appellate advocacy. So it stays with you. I mean, the values, particularly what you learn. I learned as much from the community people that I worked with as I did from lawyers, because the people that I worked with in the community, first of all, were very, very intelligent, and they'd seen an awful lot that I had never seen. They could help me analyze legal problems differently than I might have analyzed them in a law school setting.
Sure.
And they also helped me to articulate the positions of my clients better than I could have done it with just a formal education. So I think the answer is it was a profound effect.
And I really appreciate that your last comment there of what you learned from clients and folks who live in those communities you're trying to serve, and how we in some sense really are interlopers, and we need to be able to speak for them, but not what we think, but what they think. I mean, you said it much better than I think.
I had a meeting with a woman, but if she ever sees this tape, she'll probably kill me, but her name was Ida McKinney. Ida came out of the neighborhoods and sat on the Community Action Program Board. And my first day on the job at Neighborhood Legal Services, Ida came in and said to me, "What do you think you're here for?" And I said, "Well, I'm going to take my education, training, and experience and apply it to the problems of my clients." And she said, "No, that's not why you're here. You're here to help the client do what the client wants." And, of course, she's absolutely right under the rules of professional conduct, let alone any other reason. But I never forgot it, and I never forgot Ida. I still think of Ida.
Yeah. She was a wise woman for sure.
Yes.
I've sort of run through the questions that we're trying to ask of everybody, but I want to give you a chance if there's something else that you think that posterity ought to remember and know about Neighborhood Legal Services, or about your career or the clients or the experience that you had, again, particularly in those earlier days.
I'm just looking I have some notes here, but I think that I'm interested in, just take another second here.
Sure.
Well, we started in the 60s. If you don't talk about legal services and you just talk about the 60s, everybody understands the context that we were working in.
Right.
Whether it was the civil rights movement, whether it was the women's movement, whether it was the environmental movement, the consumer movement. You know, Ralph Nader comes out of Hartford. It was a very dynamic time, and you would know better than I, and I've been interested because I've heard a little bit about this from friends back in Connecticut. I don't know whether the support that legal services got, at least when I was there, whether that's still true. And if it isn't, that would be a very sad commentary.
Actually, it's interesting that there is a great deal of really genuine political support for legal services in Connecticut. I find that really interesting because when I started in Town and Windham, of course, we were really in hostile territory and fought not only with the local bar association but with the state government and everybody. But most of the funding for legal services in Connecticut now, it really is generated by the legislature. Some direct appropriation, they've increased some filing fees in the last several years when the IOLTA funds took a dive when the recession started. The state legislature and the government, the governor, have stepped in, and so that the funding is not quite as much as it had been under IOLTA, but relatively there, and at least the integrity of the legal aid programs has been able to be maintained. And it's because there's some real good political support, and the Connecticut Bar Association and lawyers in Connecticut are all genuinely very, very supportive, and I think that has made the difference in Connecticut, just as the ABA has made the difference in protecting the national legal aid network.
I'm really glad to hear that. Yeah. That's great.
Yep. Yep.
You've had a long career yourself. You know, you and I didn't really know each other.
No.
We were back here, but I've heard your name over the years, and you've had a long career in the field. I should be asking you the questions instead of you asking me.
Well, we're gonna try and get me on tape too, so that I can tell a few stories and recall the old days as well. But you're absolutely right. It's certainly interesting career, no question about it, and wouldn't have had it any other way.
Yes.
And we can both be grateful for the opportunities that we had
yes.
to do what we did. So
I want to just second that.
Right.
When I was a law school dean for quite a while, I used to tell all my students, it's a privilege to be a lawyer.
Absolutely.
It's a privilege. When you know where I came from, where my family came from, and what they saw in their lives, to be actually, if somebody to hand you a license and say, go do justice, that's a privilege. And I have never forgotten what a privilege it is.
No, absolutely. Well, Howard, thank you for your time.
Thank you
for the work that you did and your contribution to the effort that we've all made together. Thank you very much.
Thank you. Pleasure.
Thank you.